Thank you very much. So we are in the final panel. And before we turn to the presentations, I would like to say a few words. Thank you, Klaus. Thank you, Viviana. Thank you to all the members of the Advisory Council. Especially, thank you very much to the team of the Academy, Petra, Frauke, Evelyn, Marian, Kiran, Salim, the interns, Besa, Yolana. Was great. Merlina too. was amazing to have the opportunity to build this conference. I think it has been great. And I think that we have a lot of things to discuss after the conference. So thank you very much. So our last panel will deal with the mechanisms for protection of human rights defenders. Basil Fernando raised the issue with his final question in the previous panel, but the violence directed against human rights defenders is often an early warning sign for subsequent and widespread violation of human rights. We would like to understand how we can stop that and what could happen once the violations against them occurred. The chair of this panel is David Tolbert. Currently, he is a visiting scholar at Duke University, and he is also a member of the Advisory Council of the Nuremberg Principles Academy. David, please.
Thank you very much, and I appreciate all of you staying for the last panel. I think we've got a great panel to discuss some really important issues. And I'm looking forward to the conversation. I think if we're serious about protecting human rights, we have to protect the progressive social forces that drive the human rights movement. Civil society actors, human rights defenders, they're on the front line of advancing human rights and ensuring that human rights are protected both in the here and now, but also on the longer term. So I think it's appropriate that we end the conference with a discussion on how human rights activists can do their work and advance human rights without intimidation and threats. But I think we also have to recognize that a lot more needs to be done to protect these human rights advocates and to protect human rights defenders. So this panel, and I'm delighted to say that I think we've got some great experts here, is going to give a critical overview of the existing mechanisms and focus on human rights defenders at various levels in societies. So we'll be looking at what states and the UN mechanisms do or do not do to minimize threats to these very important defenders of rights. I think we have to be honest with ourselves in this discussion. The UN has established a variety of mechanisms that are intended to protect human rights globally, but sometimes these measures are not effective or don't adequately protect human rights defenders. So I think we want to critically examine this. The question is, how can the UN system and other organizations improve both the monitoring of state engagement and compliance with international obligations? It's worth noting that violence directed against human rights defenders is often an early warning sign of subsequent and widespread violations of human rights as well. So we need better and more meaningful institutional engagements to promote understanding and recognition of human rights defenders' work. It's also clear that legal standards that apply to state behavior should extend to other actors that attack human rights defenders. And states have an obligation and a duty to protect these defenders and to punish violators, but frequently this does not happen. There are a number of deficiencies in the design of these existing protective mechanisms, and we want to explore that. At the domestic level, there's a lack of resources and oftentimes enforcement, and some dysfunctionality hinders the work of national human rights mechanisms. So in a range of cases, their national institutions need reform in order to comply with international standards. And they need to increase cooperation with regional and international mechanisms. So for this panel, I think we have a number of important questions to address. I would list 4, but I think they're more than that probably. One is, what steps are called for to strengthen institutional protections for human rights defenders? A second is, what are the key lessons learned from previous experiences? A third is, what challenges identified by the mechanisms designed to protect human rights defenders can help inform the implementation of UN Agenda 2030? And finally, how can these mechanisms and systems counter the increasingly arbitrary power of states, and what role can non-state actors contribute to this protection? Now, I think we've got a terrific panel to discuss these issues. To my right is Basil Fernando. He's a very distinguished jurist and human rights activist. He's also a prolific writer and a poet. If I read his CV, we would take most of the rest of the afternoon, so I will stop there, but I want to note that he is a member of the Asian Human Rights Commission, which is an NGO actually, and he's worked on these issues for 25 years. He's worked extensively in Cambodia and in Asia as well. At the far end, we have Robert Magisa, who serves as a Senior Program Officer for Advocacy at the Human Rights Center in Uganda. He's a very active human rights defender, and particularly focused on the role of women and girls' contributions as human rights defenders, and he's worked extensively in this area. And then here, and our first speaker will be Dilnosa Saratova, and she is a human rights advisor at the Organization for Security and Cooperation in Europe, OSCE, the Office for Democratic Institutions and Human Rights, or ODIHR, as I recall it. She's worked on human rights defenders issues at UNHCR as well. And I will ask her to be our first speaker, and then we'll go to the other speakers and look forward to a very interesting conversation. So the floor is yours. Thank you.
Thank you, David. Good morning. Well, good afternoon, actually. Good afternoon, dear colleagues. First of all, I would like to thank the Academy on behalf of the OSCE's Office for Democratic Institutions and Human Rights for inviting us to be part of this important initiative. In my today's presentation, I will focus on 3 main areas. First is the work of ODIHR as a regional mechanism on the protection of human rights defenders. So this will be some practical example of how and what regional mechanisms do in order to protect human rights defenders. Then I will speak about key trends and challenges that human rights defenders face in the OSCE area, but since this topic was extensively covered in the previous panel, I'll just mention a few challenges that we find most pertinent in the region, and also maybe single out a few promising or good practices that exist in this area. And finally, the third area of my presentation concerns the challenges that we face as a regional mechanism on the protection of human rights defenders, and areas that would require further development or strengthening. So in our work, we are also guided by a very broad and inclusive definition of human rights defenders as stipulated by the Human Rights Defenders Declaration, UN Declaration. So every individual or groups of individuals or institutions that work to protect and promote human rights by peaceful means are human rights defenders. And here I would like to recall maybe coining of human rights defenders by Amnesty International, but also the UN Special Rapporteur on Human Rights Defenders, who said that human rights defenders are ordinary people doing extraordinary things. And I can very much relate to this very simple, straightforward definition because, and I can add from my side that the extraordinary nature of their work also majorly relates to the complex environments in which human rights defenders operate and frequently dangerous environments in which they operate. So the OSCE as an organization and ODIHR as its human dimension institution works in the region of 57 countries, ranging from Vancouver to Vladivostok. So you see that it's a region with various political contexts, economic and social contexts as well. So with this in mind, the strengthening the protection of human rights defenders is the priority, one of the priority areas for our office. And in our work in this area, we are of course guided by OSCEs commitments in this area. And I have a few slides for you on this. So the framework for our work in this area is OSCE's comprehensive concept of security, which basically provides that lasting and sustainable security is only possible to achieve if political, military, economic, environmental, and human dimensions of security are advanced in a comprehensive manner. Other key human dimension commitments in this area include those adopted in Helsinki in 1975, which recognizes the right of the individual to know and act upon rights and duties of individuals, but also other commitments that build on this. In Budapest 1994, OSCE participating states acknowledged that there was a need for the protection of human rights defenders. Most recently in Astana summit in 2010, these and other commitments in this area have been reiterated by OSCE participating states. So also SDGs do not prominently feature in our work on the protection of human rights defenders. We do actively contribute towards the goals, especially number 5 and number 16. So in line with our mandate to assist OSCE participating states in implementing their human dimension commitments, we've been engaging in this area of work for almost 2 decades on the protection of human rights defenders. And maybe a few words about our mandate. As you see, it's a very broad mandate, which is definitely an advantage because we can work on a variety of issues that relate to human dimension. And for those who are not aware about OSCE's human dimension, this is an area that covers not only human rights and fundamental freedoms, but also matters pertaining to democratization, tolerance, non-discrimination issues, election issues, and also protection of Roma and Sinti. So the mandate is very broad, but the key here is that we are put in place, we are an institution that is tasked to assist participating states. So more often than not, of course, we need to discuss with states the conditions under which we can assist and the type of assistance that we can offer to participating states. So, as I mentioned, we work on this topic for about 2 decades. Earlier, we had a contact point on the protection of human rights defenders that was recently strengthened to become much better funded and well-staffed program, again, relatively. There are 6 staff members at our institution that work on this office. In this team, I coordinate ODIHR's work on the monitoring of the situation of human rights defenders. So one of our sort of flagship products, let's say, is the guidelines on the protection of human rights defenders. I have just one copy of it that I brought today, which I'll be happy to hand over to the library of the Academy. But this is a document that is a product of our decades-long monitoring, including of good practices. The guidelines were developed, of course, in very close cooperation with civil society organizations, especially with Civic Solidarity Platform, which was instrumental in advocating for the elaboration of these guidelines. On page 2 or 3, we stipulate here that we do not seek and we do not, of course, set any new standards or sort of single out human rights defenders as a specific special group that requires special protection. But what we say is that we would like to concentrate, basically focus on the rights of those people who face various violations and limitations of their human rights and freedoms because of their human rights work. As such, the guidelines are intended to promote and protect human rights for all. So very briefly, also on our monitoring work, we do regional monitoring. And in 2014 and 16, we conducted a study, the first study of its kind that covers almost 85% of the OSCE region on the situation of human rights defenders. And the study is entitled The Responsibility of States, Protection of Human Rights Defenders. I also have one copy of it for those who are interested to take a look. Basically, the study is based on the questionnaires that we developed and then sent out to all 57 countries, human rights institutions, and over 500 civil society organizations across the region. And based on the input that we received, again, which covers 85% of the region, we produced this report with, of course, the recommendations. As a next step to this work, and this is a new area of work that we launched just last year, is a country-specific monitoring work or assessment work, where in this cycle we included the countries that are listed on the screen, basically having a series of meetings with various relevant actors and preparing country-specific reports that are non-public, but there will be also a public report that we will issue later this year. In this area of work, we very closely coordinate with the UN Special Rapporteur, who I know is currently in Mongolia as well, doing the country visit. So we will have 2 reports on Mongolia very soon. Mention briefly our work on individual cases of human rights defenders, where we actually raise cases of human rights defenders at risk with participating states directly, with the governments, through diplomatic correspondence, bilateral meetings, or in some exceptional cases, public statements. Most of our work on individual cases is non-public. Legislative assistance is another area of work that we do, maybe just to flag that we can perform legal reviews of laws and their compliance with international human rights standards upon request of parliaments, of government, of courts, of NHRIs, and of OSCE field operations. We do not perform this work upon request of civil society organizations. We do quite a lot of capacity building work for human rights defenders as well. Just to flag that we started actually also in response to challenges that we identified, working on a new area which concerns the developing digital guidance and digital capacity building tools for human rights defenders on safety and security issues. So we are gamifying our capacity building materials, and also currently we are developing a platform, an online platform for human rights defenders in order to provide them a hopefully safe digital space to exchange. So good practices. Again, these are the results of our study that we published in 2017 that covers 2 years. These are not, let's say, these practices come from individual countries and they are not reflective of the situation in the region in general. But we are happy to see that in some countries the gender-responsive and gender-sensitive policies and programs that are being put in place to protect human rights defenders, recognition of the bias motivation of crimes against human rights defenders as an aggravating factor in sentencing, and protections of journalists, whistleblowers, etc. So you see on the screen, maybe just last one, protection measures to support that human rights defenders at risk from other countries. We see that a number of OSCE participating states make protection of human rights defenders as their foreign policy priorities. And many countries do put in place so-called shelter programs for human rights defenders where they host those from third countries. I actually wanted to change the slide. On challenges, here also very briefly 3 points. First is we observe that laws that govern the functioning of civil society organizations, their registration, their access to funding, and freedom of peaceful assembly association in general are becoming increasingly restrictive. And a colleague from Amnesty International spoke about this already, so I will not elaborate further. We do observe and document that human rights defenders across the region are subject to threats and to attacks by both state and non-state actors, and for which perpetrators are often not held to account. A trend here that I would like to emphasize is that there are increasing number of reported threats and attacks online, which is also an area that we would like to work on more in the future. And the third challenge is that we identified is widespread discriminatory smear campaigns against human rights defenders for their legitimate activities, for their political opinion, for their affiliation with certain social groups. Among most vulnerable human rights defenders in the OSCE region, we can name women human rights defenders working on a variety of issues, those working on ethnic minority issues such as Roma, protection of Roma and Sinti, also those working on LGBTI issues, environmental issues, and those working on anti-corruption, including investigative journalists. And maybe I will conclude with some of the challenges that we face in our work and the areas that we would like to, we identified for further strengthening. So there was a discussion on this already, but I would like to re-emphasize this. There is a need for renewed commitment on the part of states and strong political will to protect human rights defenders. Second, there needs to be more strengthened coordination and cooperation among various regional and global international mechanisms on the protection of human rights defenders, including on strategizing our joint contribution towards the SDGs. Number three, we need to strengthen our engagement, all of us, I say as an international community, to support grassroots civil society organizations and human rights defenders working at the local level and build their capacity. Here just briefly mention that psychological well-being of human rights defenders is a huge challenge that is very often neglected and that has to be addressed as well. Number four, there is a need to engage with private sector actors as well, and we talked about this today. Human rights defenders that we work with bring to our attention the need to cooperate and work with tech companies. Again, it was said that online platforms are great tools for human rights defenders and promotion of their work, but those are also platforms that through which human rights defenders are harassed, targeted and intimidated. So there should be a dialogue with tech companies, with companies working on mining and construction projects, so that we can discuss their role on the protection of human rights defenders, but also impact of those companies on safety and security of human rights defenders. Number 5, we need to strengthen the capacity, our knowledge and skills on the use of technology on human rights work, and this concerns not only human rights defenders that we operate with, but also ourselves as a regional mechanism, as ODIHR, as an office. And I will conclude with the last point, which is, again, was mentioned already yesterday, at yesterday's discussion. It's important to be able to assess the long-term impact of our joint activities, which is, of course, crucial in this work. Thank you.
Thank you very much. You raised a lot of important issues. Something we hear a lot about is the kind of shrinking of the civic space, which I think you rightly highlighted. One of the important things I thought you mentioned was both state and non-state actors involved in threats and intimidation and growing threats. Just one question, if you don't mind, before I switch. In terms of these growing threats, and you identified at least 4 or 5 or 6 of these, just wonder what is causing the biggest concern for your organization and your work in terms of threats vis-a-vis human rights defenders. What is the trend that is most disturbing, and do you have strategies to deal with that?
So in terms of biggest threats, I would say lack of political will on the part of states to implement commitments that are in place already. Second is the overall sort of increasingly shrinking civil society space, which we can clearly observe by laws that are being adopted and policies, etc. So again, there were some statistics provided by a colleague from Amnesty International, but this is also very much relevant to the OSCE region. And the third one is actually to understand to what extent technology and various online tools, basically understand the digital or online dimension of threats that human rights defenders are exposed to. And again, in response to these 3 areas, of course, we do engage at various levels through diplomatic channels, but also, as I mentioned earlier, there are a few new things that we are doing as an office. Those include the country-specific work, monitoring work, which you can imagine is not very easy to implement and to convince states that this is important to do. That's first, but also our work more that is directed at digital technology and sort of equipping human rights defenders and ourselves as well as a mechanism with this knowledge and skills so that we can be, if not on the same level, but with those who use these skills against human rights defenders. And there are many such actors.
I have a bunch of other, because I want to turn to Robert now and ask him to make his presentation, particularly relating to countering the increased arbitrary power of state mechanisms, which I think you're seeing a lot in your region. So, Robert, I give you the floor, please.
Thank you so much. Robert Mugisa is my name. I work with the Human Rights Center Uganda. Let me join my colleagues to thank the Nuremberg Principles Academy for organizing this conference, and also Dr. Navi for always encouraging us to promote rights. Margaret should have been here, Margaret Sekaja, our ED, but she chose to send me because of the trust that she has, because of my work as an advocacy officer, but also someone who has spent about 6 years at the organization training human rights defenders on understanding their work. I'd like to say that international criminal law and the UN mechanisms have a lot in common, and that is the desire to promote human rights for all. Of course, I am a student of project planning, and one of my units was understanding the Sustainable Development Goals. I must say I passed highly that coursework because of my passion in understanding these SDGs and applying them. So the concept of leaving no one behind is very crucial, and this discussion, of course, is a build-up. And where we combine the international criminal law and the SDGs, we will see a lot of advancement in the human rights movement, especially as we seek to promote all these 17 goals, but focusing on SDG 16 for purposes of this conference. So a lot has been said, and I don't want to repeat myself on that. But specifically, I must say that I appreciate the existence of the international mechanisms for protection of human rights defenders. When you look at the treaty bodies, the special procedures, the UPR, the international courts and tribunals, all these are aiming at seeing that human rights defenders are protected. When you look at 2016, experts came together to put together the model law on the protection of human rights defenders. And in my country, I'm one of the people who are sitting with other coalition members to see that we have a domestic law on the protection of human rights defenders. Then at the regional level, we have mechanisms like the African Charter, which establishes the court, the protocol, but also the commission that we've been talking about. And then we also have the East African Court of Justice and also the Legislative Assembly. All these are avenues where issues of protection of human rights defenders can be channeled and discussed at different levels. And then coming to the national level, I know all of us are representing different countries, and our experiences may not be so different, but we have ministries, departments, and agencies of government. We have national human rights institutions, civil society, where I fall, and then we have individual human rights defenders that are passionate about promoting human rights, and we cannot leave them behind. And then I'll also notice that governments and human rights defenders have a lot of opportunities behind closed doors and discussions to achieve more. So even as we step out of this conference, there is quite a lot that we have learned on which we have to put our hands to see that we continue the message of promoting human rights. A lot has been said about who a human rights defender is, but I'll emphasize the fact that even when I'm training human rights defenders, I usually emphasize that under Article 1 of the UN Declaration on HRDs, this is the breakdown, that everyone or anyone, individually or in association with others, promotes or strives for the protection. And usually in the trainings, we break down what promotion is, what protection is, what human rights are, what fundamental freedoms are, because these are local HRDs that we are dealing with, and they must understand these concepts well in order to apply them. So at the national, international, and then the regional level. I've put national in brackets because the declaration does not spell it out, but of course it's important for the discussion. And to emphasize that human rights defenders promote civil, political, economic, social, and cultural rights. And much as there is no particular qualification for one to be a human rights defender, we have developed standards as an organization to say that we must emphasize the fact that actions done by these people must be aimed at promoting human rights, not their own interests. They must be working within the law, they must use peaceful means, and they must work within a given context. And I think that's why, as Eduardo and team were looking for human rights defenders, they identified particular contexts in which we operate and called us. Now, back to our dear moderator, David. You asked us pertinent questions, and I just want to run through them for purposes of time. What steps are called for to strengthen institutional protections? I have mentioned that at the national level, we have existing institutions, but we need to further strengthen them. One, by ensuring independence. Many times we see OIC, that there is a lot of interaction and interference of the major institutions that should be protecting human rights defenders, especially by the executive. You know, they know what to do, but they don't do it because in order to take a decision that will promote justice, someone must advise people within the institutions on what step to take, and that compromises. So for me, I think we need to kill the compromise and clear the consciences if we are to achieve on justice and peace. Number 2 is coin, discuss, and allocate sufficient budgets. When you look at the challenges affecting human rights defenders, financing will always come up, but I think for us, we need to intentionally and rigorously fundraise as partners to see that a lot is allocated to justice and justice for human rights defenders. Building capacity has been talked about. I will emphasize the fact that we need to build the capacity of the leaders. If we, for example, talk about training the police, we are not looking at the Inspector of General Police. We want even that officer who is guarding at the gate to have capacity built on how to promote human rights, because he or she or they are human rights defenders as well. So many times we have the challenge of looking out for the top management, and we forget the middle and the lower cadres who also need this capacity. We need to strengthen, equip, and make sure that the internal systems within these organizations are running well in terms of their programs and how they can document and report on human rights issues. Building values that last, I think, is also another step that we can take as human rights defenders, but also as partners, in order to create unshakable principles or values which these people, even when they leave the organizations and institutions, can continue to promote. So just to wind up on that, I'd like to say that many times we want to build nice structures. Courtroom 600 is very okay, beautiful, but beyond paintings, the people who are within the courtrooms must have values so that as they make judgments and decisions, they must be able to take decisions that will promote justice for all, not just earning their salary and driving posh cars, but also the values that they have will help to check. So what are the key lessons we have learned from previous experience dealing with these mechanisms and also implementing, conducting our work? One, there is a sizable degree of willingness on the part of the state and also institutions to receive and work with human rights defenders. The challenge we are still having is who is a human rights defender. I remember one time as we were moving to the Ministry of Foreign Affairs advocating for the law in our country, the minister asked us, so, but I think everyone is a defender, so who do you want to protect? And so we had to explain to them that there is a particular group of people who are passionate about promoting human rights and protecting them, and those are the ones we are seeking protection for. And so it's a continuing work that we have to do. And then there is suspicion still continuing over the work of human rights defenders, and we have had experiences where organizations have been broken into because of the work that the human rights defenders are doing, just to check what are their computers holding, what are they exactly running up to, are they against the state, or are they seeking to impress the development partners? So that suspicion is still there. And then also we've learned that there is engagement and involvement of all stakeholders is very crucial. Bottom-up means, can I begin with the grassroots HRDs and then discuss their issues at national level, then we can go to the international level. So we need to do that as much as possible. And without empowering the beneficiaries to speak for themselves, human rights defenders tire. We speak a lot to ourselves, and then we forget those for whom we are speaking. So we need to engage them. And then communities want real solutions and not possible solutions is something that we keep learning all the time. Challenges, my colleague Satarova has talked about them, but maybe I will emphasize the interference of executive powers politicization of human rights work. Whenever we speak about the need to improve situations, it's more of a political question. And as I speak now, I've been discussing with some colleagues, people who seek to talk about human rights for all are taken to be as enemies, and that is visible, which we need to fight. Weak legal institutional frameworks, again, I've said we need a law that protects human rights defenders if we are to achieve justice for them. Limited and narrowing financial space, financing for human rights defenders' work. Ignorance among leaders on HRD's concepts, human rights-based approach, and Agenda 2030. Those are preserves of people who can sit and learn and do research, not for the leaders, because they are not willing. She talked about the limited political will. Negative attitudes towards SDGs, Agenda 2030, is still a challenge. And then corruption and bribery tendencies, things that we see challenging the work of protecting human rights defenders. How can these mechanisms, therefore, check the arbitrariness of the state? Of course, it's a continuing call to those who can assist to continually remind the state of its core role. RPF, respect, protect, and fulfill human rights. We also can use these mechanisms to strengthen those departments of state, especially on the question of impartiality in holding perpetrators of human rights violations and culprits accountable. Then, of course, the policies and laws we continue to push in order to see that they work. Strengthening national coalitions. I believe and know that in different countries there are growing coalitions for human rights defenders. We have one in our country, and therefore it's important that these coalitions get enough support, because it's a movement that can, at the end of the day, build lasting strategies for protecting HRDs. Strengthening the monitoring, documenting, and reporting mechanisms, regular dialogues like these ones, and then taking advantage of the media. Many times I speak at our local radio stations about the concept of human rights defenders, and there's always feedback from the communities. The challenge is, after you've made a very good talk on the radio, you'll hear people calling, "Hey, Robert, thank you so much for your talk, but we don't see you. We are not seeing you. People are suffering. People's rights are violated. Where are you when we need you?" So we can continue to advocate, but also be able to reach the ground with human rights defenders to see that lasting solutions are given to the people who are asking such questions. And then lastly, each of us is a human rights defender. Advocacy is the way to go. It may not seem so clear right now, but we continue talking and partnerships, we can later see the impact. And then the time to implement and see the fruits of the UN agenda, SDGs, and the discussions that we have is now, not 2030. And then I just put there because in my other time, I compose human rights songs, and when you go to the link that I've given, you'll be able to find some of the music that I've composed and produced to advocate for the promotion of human rights. And of course, more of these discussions can be found on our website that I've also shared. Thank you so much.
Thank you for that, and you put a lot of ideas on the table. I have a list of 10, and I just kind of ran out of space. And I didn't include music, so that's 11 or 12. Just a very quick question. You listed a number of big challenges, killing the compromise, which is a phrase I liked, sufficient budget, capacity of leaders, building values, new structures, and so forth. You had a lot of challenges, and you had some strategies, I think, to deal with that. If you had to kind of make a judgment, what do you think is the biggest roadblock in implementing the strategy? And what keeps you awake at night when you're dealing with trying to figure out what to do?
For me, the biggest roadblock is the power question. I am a lawyer, and before I became the advocacy officer, I was the legal officer. And I used to receive a lot of complaints from human rights defenders, walk-in, call-ins, and also field work. But all of them seem to be asking the same question: where are our rights? And then when you read through the cases, you find that there is one person somewhere who is holding the rights. Remember, we are saying these rights are universal, interdependent, inalienable, inherent, when we spell out the principles. So as a human rights defender, the question I have, how do I speak to this person who has the power to give it to me, or the rights to give them to me? Yet the controversy is these are natural entitlements. So if it's freedom of speech, if it's freedom of association, if it's the right to life, it should be free, everyone should enjoy. But the fact that you have to say, please, we need some of our rights, is the roadblock that is preventing us from achieving. So the issue is the state, for me, is the state. You'll realize that in many countries, the state has absolute power. It has a lot of power to decide on what to do next. So unless we deal with the question of the state, the leaders that we have at the time, then it's very difficult to break through on some. And what we have done to address that, or try to address that, is the regular dialogue. We have gone to the level of reaching out to ministries and tell them, one, about the concept of human rights, but also give them evidence of cases of people who are suffering innocently, who need to enjoy their rights. You'll find many in prisons, like someone said, but there are no cases against them. But they are in prison anyway. What do you do to get them out? Talk nicely to the authorities and press to see that at least they come out. Even when they come out, you still have to continue talking to them. Yeah.
Thanks very much. Now we'll turn to Basil, and he's going to be focused on the importance of non-state actors in the protection of human rights defenders, and he brings an enormous amount of experience, as we talked about earlier, so I give you the floor, sir.
Agreeing with many things that have been told. One of the things that really gladdens me about this meeting is that I think, almost complete consensus on the inclusion of Goal 16 in this Sustainable Development document. This is, quite rare, that the aspect of justice in its most comprehensive sense being at the heart of dealing with a human rights problem. And in this case, I think the greatest problem is poverty. Bringing that focus consensus, in a way, this meeting can be a beginning of a reorientation of the human rights work in the possibility of bringing this Article 16 to a greater focus, and also in the training and education of human rights defenders themselves and civil society groups, if efforts are made to go into the depths of meaning of this Goal 16, I think we would begin to see gradually a change and a new dynamism in the human rights field. That said, the Goal 16 for the purpose of poverty issue is new, but similar provisions were there already, beginning from the Universal Declaration, particularly the two covenants, the civil and political rights and economic, social, cultural rights. In the civil political rights, the Article 2 is identical in words to the similar provision in the Declaration of Human Rights, that the judicial, legislative, judicial, and administrative measures will be made in order to realize these rights. So we are talking about a well-established principle, not any innovation, but the importance is that it has been brought to a very sharp focus in terms of poverty. Now, in terms of what we are talking about now in terms of human rights defenders and civil society and the non-governmental organizations work in general, for those of us who are coming from the less developed countries, we are talking about a crisis, a very serious crisis that is affecting the peoples of these countries. I will try to demonstrate this in terms of a few points from the Asian, number of Asian countries. We virtually have been working on about 11 countries for last 25 years. I will just mention very few points of the visible nature of the kind of justice systems that has emerged recently. First, there have been large-scale killings under various pretexts, such as counter-terrorism and against insurgencies, and drug control and suppression of crimes. These illegal killings include large-scale extrajudicial killings, including, in most cases, enforced disappearances. I think the issue of enforced disappearances is not some minor issue in the human rights field. It is a major issue if you go by the experiences of Asia. The President Duterte of Philippines, one of the countries one time was a very promising country for human rights. He ordered from the parliament that anyone who has any connection with the drug trade should be shot dead. Within less than 3 months, about 5,000 of, that is official figure, about 5,000 people were shot dead. The unofficial figure is much larger. And these include not just about people who deal with drugs. It means environmental activists and various forms of people who are opposed to the government. So large-scale killing, illegal killing, is part of the today's system of so-called justice, or you can call it system of injustice. The second point is the practice of direct punishments carried out by security forces under policy direction given by the executive. These punishments include matters mentioned in the earlier paragraph. The extrajudicial killings, the enforced disappearances, and the like. The shifting from the punishments given through fair trial and thereafter judiciary sanctioning the punishment, we get the executive giving the orders to have direct punishments. And this is also not a small-scale problem, it is a large-scale problem. The third is that fair trial become unattainable goal partly due to the practice of these direct punishments. There are other insurmountable difficulties that virtually makes the search for justice and fair trial a futile exercise. The causes for this include long delays, which will take, according to the parliamentary committee in Sri Lanka, a criminal trial could take from 20 to 23 years. Now, it virtually makes the whole exercise very difficult, even for human rights defenders to stick to a case for 23 years, and to protect a person for 23 years is a very hard task. Having done it in few cases, it is near impossible task, because the perpetrators of these crimes get a 23 years to go behind the complaining victim. Fourth aspect is, while constitutions are couched in attractive language, the practice of constitutionalism has been abandoned in favor of direct executive actions which may or may not conform to the provisions of the Constitution. A constitution is more of a paper document. You know, the Cambodia in I was at the time working for the Cambodian Transitional Authority. In 1993 May, there was the election. The party that lost did not want to give up power. So therefore, for the extraordinary case of two prime ministers, one from the winning party and one for the party that lost, because the party that lost controlled the military. Within 4 years, the party that lost by a coup defeated the party that won, and from then on, he has been winning, of course there had not been any fair elections in huge numbers. Now, here, the whether an action is legal or illegal has mostly become a matter of irrelevance. If you challenge, because you must have a place to challenge illegality. If the courts are brought under the control of the executive, where do you challenge the illegality of an action done by the executive? So, in many instances, simply mere fact of illegality does not make an action void or null and void. The result of all this type of situation is that torture, like earlier I mentioned about the extrajudicial killing, is the most common methods of inquiring into crime. When I say crime, I'm not talking about very extremely serious crimes. I'm talking about petty theft. In many of the countries, in Asian context, when a person is brought to police, they expect that he will be beaten. So the result is the family will beforehand try to give, bribes, and so long as he is kept in the police station, every day they have to give bribes. So we have done enormous amount of work on the torture issue, and I can tell you without any hesitation, torture is the most common method used in every investigation. And in an academy in China, when we had a police academy, they said, we don't torture everybody. It is only when we are sure that this is the fellow who did it, then we want to get the information, then only we do it. So the cumulative effect of all these factors is that denial of justice has become a common mode of practice as a result, most people in the countries have lost their faith in the legal and judicial system. And this is a very grave problem. If the people lose faith in the judicial system, then who is to give the strength and sustenance to anybody who is in the judicial system who want to do something? When they are attacked, when the judges are attacked, nobody comes forward to defend them, because already people have lost. So when they are lost of faith, what do? They resort to other methods of solving their problems. They go to big politicians, and the politicians dictate terms to the police and the others, and they may get something that way. But in fact, by way of law, the people do not believe that they have a fair chance of defending themselves. As a result of this has a direct impact on the legal profession. The legal profession in most of these countries is highly intimidated because of various repercussions, and as a result, the surviving members, there are many who just quit because they know they no longer can practice law. But there emerges opportunistic elements in the legal profession which will exploit all these things for unprincipled methods of doing various types of things. This is just a very short summary of the most common features of the so-called legal systems that are there in most of the Asian countries today. I say by most, there are few places where still there is a rule of law system, and there is respect for the judicial independence, and that is very, 2-3 places. The rest of it, the conditions are these. So when we are talking about the goal 16, we are talking about changing that this situation. And how can you change such a situation? That is a question I think we should address. The most disheartening factor today, because of these conditions, is that in the civil society actors themselves and NGO movement, there is a heavy sense of demoralization. Because to seek a remedy, they have no place to go. So I think the education of the civil society into the meaning of the goal 16 and how to do this. This is an extremely sophisticated type of work that you have to do in order to get the context. There was talking about context. To get the context articulated, to get it to the surface, people have to do an enormous amount of work, but that could be done only if they understand how to monitor a judicial institution, prosecutorial institution, policing institution, and the like. Now, there are many courses teaching LLM human rights. All those courses have a very important aspect of the international criminal law. But I asked one of those professors, do you teach how to monitor the local, domestic criminal law in your country? That is considered not a part of international law. So the result is there is no actor coming forward in order to challenge this. But if that can be done in the same way that we earlier trained human rights defenders in the 60s and 70s to articulate principles. But today we have to articulate practices. Just to finish it with an anecdote, the group of people coming from in Cambodia, from distance far away. On the halfway, they found a group of people, and then a man tied to a tree. And one man in the crowd had a gun. So they stopped, the UN group stopped there, and then they went asked, what is happening? They said, this guy has abused one of our girls. So we are going to give him the punishment. That is, we are going to kill him. Then he was asked, can you do something less than that? Is there any way of, punishing him, but at the same time not to kill him? He said, there is nothing like that. There is no court here. There is no police here. There is nothing is here. Either we set him free, or we have to give the only punishment that is possible. So the result was that, of course, fortunately, UN had some prestige at that time. So they took the man and they said, we will organize. And then the Dutch government had to give money to build a prison to keep the man, to build another building in order to hear his case. And that's the kind of vacuum that exists in the field of justice. And a human rights defender, in order to do his work, must constantly depend on a functional judicial system.
Absolutely. Thank you very much. I have some questions, but we only have, I think, 25 minutes. So I think what I'd like to do is open up the floor and take questions from all of you. I see a hand back there, another one over there. Why don't we take 2 or 3 questions at a time, and we'll let the panel respond. Yeah, that's fine.
Hi, my name is Umair Nazir, and I am currently studying at the FAU Alexander Erlangen, Nuremberg. Before coming here, I was working with this organization called Association of Parents of Disabled Persons in Indian-occupied Kashmir, where I was engaging with the victims of enforced disappearance. So I was a human rights defender. I'm currently, with my primary focus is Kashmir. So in 2008, Office of High Commissioner Human Rights took out a report on Kashmir, and because some of the organizations, particularly our organization, APDP, also provided information for the report. So what happened, the Indian government pressurized all the organizations which supported the report, which provided information for the report. So what happened post the release of the report was one of the human rights defenders from Kashmir had to leave Kashmir for several months, and I also had to leave my job because of the pressures that were coming from the intelligence officials. Also, what is happening in India also.
Could you ask a question? Because we have very little time.
I will just have a suggestion. What is happening in India currently is also there is a pressures like arrests of human rights defenders are happening all over India, and recently Amnesty was also banned, and also Greenpeace was also banned in India. So I have a suggestion. If we could provide, if the United Nations can provide alternative travel documents to the vulnerable human rights defenders who cannot travel outside their countries because of the pressures by the home countries. It would be possible for the human rights defenders who are caught between the government because the government doesn't want them to engage with the organizations like the UN or other, for example, the European Parliament as well.
Yeah. Okay, thanks. Thanks for your question. There was another hand up over there. Yeah. Why don't we take 2 or 3 questions? Yeah.
Thank you. Actually, I have more contributions than questions. Is that okay?
As long as you're brief, it's okay.
Okay. Veronica Inestrosa, International Bar Association's Human Rights Institute. So thank you for the presentations. I wanted to mention one of the topics that was mentioned in the panel before, but I think it's important when looking at mechanisms for protection. It's context analysis. And I think it's one of the areas where international criminal law can really inform the work in international human rights law. We find that more often than not, context analysis for human rights, it's understood as socio-political context. And for criminal investigations, of course, it's a tool for investigating, finding hypothesis patterns. I think that's we believe that contributing or finding a way for having international criminal tribunals transfer some of the skills and the knowledge that they have gained in developing context analysis as a tool for investigation will be really helpful, for example, for stop looking at, in this case, violations against human rights defenders as isolated, but understanding that they are part of a bigger phenomenon, sometimes systematic, sometimes more than that. That's one. The second one is to mention that a protocol is currently underway. It's led by the International Center by CEHIL, the Center for International Law, and it aims at investigating threats against human rights defenders, which we believe is very important because it's understood that threats come with deciding to work as a human rights defender. So prosecutors will normally tell you, yeah, but well, you decided to defend rights, that comes with the work. And we find that threats do not only affect the individual human rights defender, but the movement. Berta Cáceres is a clear example of that, and that's why the protocol is called the Protocol of Hope, Protocolo de la Esperanza, which is where she was killed when she was a human rights defender. So that initiative exists, and I'm happy to discuss it. We chair one of the committees that is developing it. And the final is to mention that our institute is also working on a toolkit to, as some other colleagues mentioned, to shed light on the mechanisms that exist for defending lawyers that act as human rights defenders, and that's to be launched later this year in Southeast Asia. Yeah, thank you.
Very good, thanks. I'm willing to take one more now. Okay, one more, and then we're going to go back to the panel.
I would like to ask, if I may, with the permission of our sister from the OSCE, I would like to ask you, Basil, and you, Robert, a straight question. If you were given the choice of using SDG 16 to help the situation, in your case in Asia, and in your case in Africa, what is the issue that you would choose to help Asia and to help Africa? Straight question, thank you.
Very good. I'm going to return to the panel, and who would like to, want to start? You want to just come down this way, or okay. And then you, and then we'll just go down the road. Yeah. Okay.
Turn off the microphone.
Oh, sure. Oh, yeah, sure.
Thank you so much. I appreciate the feedback and the comments that have come in. The other one was more on the context analysis, which I think each of us can do, and the local contexts, the analysis, will then inform the international context, because when we combine all these contexts, then we get one. When you visit our website, every year we do a situational analysis on the situation of human rights defenders in Uganda, but we also have consideration at regional and international levels. The last report came out in March this year, and so it's available online. If I was to pick one issue at the African level that I think SDG 16 could address, for me, I think the issue is governance. Yeah.
Thank you. Maybe a few reflections or recommendations from my side on the issue of temporary protection, granting temporary protection, and also travel documents for human rights defenders at risk. Again, I mentioned that the number of OSCE states, member states, that do have in place these temporary protection programs that they offer to human rights defenders from third countries. As examples, I could name the Czech Republic, for example, Italy, and Georgia. I mean, in different countries, these programs are run by various organizations, by municipalities, for example, in Italy, and by civil society organizations in the Czech Republic and Georgia. And I mean, the best way to benefit from these protection schemes would be to reach out to civil society organizations in those countries. Because again, as an OSCE, for example, we do not issue any travel documents, but of course, for those civil society organizations, human rights defenders that we work with, we can always help with support letters, for example. Another very useful source in this context is EU's Protected Defenders project that actually offers including some financial resources to human rights defenders at risk. And this scheme is very fast in its operation. So I would also recommend you to check that project. On context analysis, I would just add that of course, we fully agree that this should be the approach and that violations against human rights defenders should be analyzed in the context and taken as part of a bigger picture, bigger system, and this is exactly the approach that we do take at the OSCE as well.
Okay, very good. I want to add a question for you because I didn't ask. I was thinking about Cambodia in particular, because I served as the special expert to the Secretary General of the Khmer Rouge trials, and there's an enormous amount of corruption. There's no doubt about that. Civil society did some good work around the ECCC. At the same time, they have to deal with a government that's totally corrupt. And we're caught in this very difficult, complex situation. And I wonder if you had any thoughts about civil society, human rights defenders caught in that kind of complex situation, advancing accountability for the worst crime of my lifetime, perhaps, at the same time dealing with a deeply corrupt government. How does one navigate, how does an NGO navigate in that very complex situation? And obviously, the other questions I'm glad to get your response to, but I've been waiting to ask all week that question.
What we have in common is that we have both worked in Cambodia. The difficulty that the human rights NGOs had in Cambodia on the judicial issue was that there was not a single person that I came across, and I really moved with the groups and work, who could understand what an independent judicial institution was. They have never seen one. They even much later, I go very often, and even today, it's very difficult to convince them that this is an area that you should work. So in order to deal corruption in itself is of course a very vital issue in terms of this thing. But in 1993, we had a free and fair election. How? It was because there was a UN intervention and there were certain principles, and that there was a sanction attached to anybody who breaks those principles. But there was the UN cadre who was able to get that message across, and there was somebody to articulate that problem. In the Cambodian setup, and my answer to Dr. Ramcharan's question also, if I had a choice of doing the first thing in order to get a kind of a discussion that can make a change, I will concentrate on training at least about 10 people from each of these countries to do how to do real ground observations on all aspects of justice. Not just only judiciary, but also judiciary, but all aspects of, and if they become articulate, you create public opinion. And without public opinion strongly on your side, and at least a very partial, very vocal group of people supporting your position, you cannot attack the issue of corruption. Now, and the other abuse, this thing. Now, if you take the example of Hong Kong, Hong Kong was a very deeply troubled place when the Japanese left, and then the people running away from the revolution, Chinese revolution, crowded in Hong Kong, and it was one of the most poorest places. But one advantage they had, that was the British have established a rule of law system. So by making use of that, in 1964, an institution was brought about called the Independent Commission Against Corruption, with one principle, that all the people who work in this commission will not include anybody at any time who have worked for the police. That they will be a professional group who will control the corruption issue. By then, the society, civil society, had quite a understanding of how they may lose in the economic field if they don't control corruption. So as a result, an institution was brought about with a new concept of corruption control, which is one of the most effective corruption control agencies in the world. Today, I have been there in Hong Kong for 25 years. Nobody ever think of giving some kind of even a bribe, small bribe. They get, even the younger generation simply gets angry even if you ever mention things like that. So there is a change of population's attitude brought about by certain articulate people who have themselves understood the significance of this problem.
Very good, thank you. Robert, I think you had one more comment to add.
Yes, I'm just following up from Basil's presentation. What we are saying is peace, justice, strong institutions. We have done so many trainings, and we are continuing to do trainings. We've done advocacy, and we are continuing to do advocacy. And we can do all this. We can discuss all the strategies. But for me, I think if the governance question is not really addressed, because within governance is where you find rule of law, is where you find the institutions, is where you find the change that we are looking for. So we can think over and over again about how to talk to the leadership of all these institutions and countries and states to come to an agreement that it's important for us at such a time as this to advocate for and implement SDG 16. Yeah.
We just have a few minutes left, so I think we would probably be much more popular if we let people go 4 minutes early rather than taking another round of questions. I think this has been a very important discussion. It comes late in the day, but at the end of the day, as I said in my opening remarks, these processes are driven by civil society. And it's progressive forces in civil society that leads to the kind of change that we're talking about, which we're focused on. And if civil society actors, if human rights defenders are not protected, that change is not going to happen. They are the starting point and the end point, really, of change in societies for the rule of law, for the protection of human rights. So I think this is the right note to end on for this important conference. I think there are going to be some final remarks. So I want some credit for saving 6 minutes and 42 seconds. And thank you all for your attention late in the day.